Let me tell you a story that still gives me chills. Not because anything crazy happened, but because everything that happened was completely preventable. A Florida woman, let's just call her Marjorie, was in her late 60s. She was independent, sharp, and had two adult children from her first marriage, a son, David, and a daughter, Lisa. 15 years earlier, while she was still up and about, working, still driving, still going to Zumba on Saturdays, she filled out a basic healthcare surrogate form. It named her then husband as the person who would make medical decisions for her if she could not speak for herself. Now, fast forward a decade and a half. That husband was long gone, the marriage ended badly, and they had little to no relationship. They barely spoke to each other. He had moved on, and so had she. But her paperwork never changed. One morning, Marjorie suffered a massive stroke in her home. She was rushed to the ER unconscious. Doctors stabilized her, but she slipped into a deep coma. No one knew if she would wake up. And when the hospital asked for her health surrogate form, the staff, they pulled up this old document. It was what they had scanned. And there it was, her long gone ex-husband. Not her son, not her daughter, not the people who knew her best today, not the people who actually loved and cared for her today. A man she hadn't spoken to in over a decade. The kids, of course, were stunned. The hospital tried to reach him, and yes, he answered. And yes, he was technically still the legal decision maker, which already set the stage for disaster. At first, everyone tried to work together, but then the medical updates became more grim. Doctors explained that her chances of meaningful recovery were extremely low. And this is where everything fell apart. You see, David, her son, he believed his mother would want everything done to keep her alive. Machines, feeding tubes, ventilators, whatever it took. Meanwhile, Lisa, her daughter, believed the opposite. She insisted her mother always said she didn't want to be kept alive by machines. Two children, two completely different memories, two interpretations of love. And now, neither had any legal authority because the law pointed to the outdated document and the outdated document pointed to the ex-husband. Now, of course, you would think maybe he would say, no, you know what? I'm going to step out of this. Her kids should be the ones to decide. But oh no, he stepped up, maybe more than he ever stepped up before. I don't know if it's because he felt obligated or entitled or maybe just guilty. But whatever the reason, he became the person the hospital legally had to listen to. But he didn't know what she wanted. They hadn't spoken in years. And the three of them, the son, the daughter, and the ex-husband, they all disagreed. And when families disagree, hospitals stop everything. They don't know what to do. They're not going to continue some treatment plan. They literally refuse to continue to provide life support. They refuse to continue aggressive treatments without direction. They turn the case over to the ethics board, to the attorneys, and ultimately to the court. Now imagine this. Imagine your mom is lying in a hospital bed. Machines are keeping her alive, and you and your sibling are barely speaking. Instead of being at her bedside, you're sitting in a courtroom arguing over who is allowed to speak for her. That's exactly what happened here. Caregivers testified, doctors testified, the ethics team weighed in, lawyers presented arguments over what she would have wanted. But the judge was not there for the emotions. The judge wasn't there to guess what Marjorie might have wanted. When it comes to an incapacitated adult, the judge can only rely on legally valid documents and clear evidence of the patient's wishes. And guess what? Marjorie had no living will. She had no written instructions, no updated surrogate designation, nothing written, nothing clear, nothing helpful. Just one outdated form from 15 years ago. That was it. And because the law had nothing else to go on, the judge followed the document exactly as is. The ex-husband remained the decision maker. Weeks passed, and for weeks, literally almost months, the family stayed in limbo. Every day was the same. Machines, alarms, tests, waiting, hoping, praying, disagreeing, crying, fighting, and the worst part? This entire nightmare was not about a medical decision or medical care. It wasn't about love. It wasn't about cruelty. It literally was about paperwork. Paperwork that could have been updated in just a few minutes. A form that could have been signed at her kitchen counter. A document that cost nothing. A document she probably thought she had already taken care of. Now, eventually, the medical team advised the court again that there was no sign that she would ever recover. And with the ex-husband still in charge and no written directions, life support continued for a little while longer until he finally agreed to discontinue certain interventions. And then Marjorie passed away. Her kids never fully reconciled. To this day, they're barely speaking to each other, all because of one outdated form. We really cannot make this stuff up. Now let's break down exactly what the average person watching this needs to know in plain English. Number one, your healthcare surrogate controls everything. If you can't speak for yourself, your surrogate makes decisions about life support, feeding tubes, ventilators, medications, surgery, end-of-life choices, who can visit, whether to pursue treatment or comfort care. This is one of the most powerful documents you will ever sign. Number two, your ex-husband or ex-wife or estranged family members are still in charge until you change the document. Divorce does not automatically revoke these forms in Florida. So that ex that you can't stand, probably still has power to make your medical decisions until you update your paperwork. Number three, if you don't choose someone, the law will choose someone for you. And trust me, you may not like the list they end up choosing from. Number four, if your documents are outdated or unclear, the court will step in. And the court moves slowly, it's expensive, it's emotionally draining, and may follow an outcome that you never would have chosen. Number five, this could all have been avoided with one updated form. 15 years, one forgotten signature, and an entire family torn apart. It didn't have to happen. Listen, you can avoid this. Updating your directives is simple. It's fast, and it gives people you love the tools they'll need on the hardest day of their lives. Please don't leave them guessing. Don't leave them fighting, and don't leave your fate in the hands of an outdated document. If this story opened your eyes, hit subscribe so you don't miss the next episode of You Can't Make This Stuff Up. And when you're ready, download my free Florida estate planning checklist. The link is in the description. It walks you through exactly what you need to protect your family before life gets messy. I'm Attorney Otto. Plan wisely, live confidently, and I'll see you next time.